Good. Well, welcome to this final session of this year's lectures on the rule of law and democracy. After our first two lectures by Neil Walker and Sheena Schifrin, we today have the honor of welcoming David Dyzenhaus. My name is Sofie Møller. I'm a postdoc at Normative Orders, and I co-organize these lectures with Gálvez Bermúdez, who is a doctoral fellow also at Normative Orders. And we're very happy to see you here and look forward to the lecture and the discussion. So today's lecture is, as it said, by David Dyzenhaus. The title of the lecture is The Legal Experience of Injustice. Professor Dyzenhaus is a professor of law and philosophy at the University of Toronto. He's had many honors and been visiting professor in many places. Among them, he's been visiting professor of legal science in Cambridge. He's been a fellow of the Wissenschaftskolleg zu Berlin. And earlier this year, he was a Guggenheim fellow and a visiting fellow at All Souls College in Oxford. He's also an author of many different books, among them Hard Cases in Wicked Legal Systems, Legality and Legitimacy, Carl Schmitt, Hans Kelsen, and Hermann Heller in Weimar. And finally, his newest book, I can show it to you here, is The Long Arc of Legality. And today, as I said, he'll be talking about the legal experience of injustice, and later we'll have comments by Chiara, Destri, and Volkmann. So please go ahead, the floor is yours.
Well, thank you very much for having me to your lecture series. I'm delighted to be joining you from Toronto, from my study at home. There might be a bit of construction noise, which is taking place in the street outside me as we go along, but I'm hoping it won't disturb things. The title of your series is, as you know, Democracy and the Rule of Law. And I'm afraid there's virtually nothing about democracy in my paper. But it is about what I call the rule of law state, and in this way, at least indirectly, about democracy. And I'd be happy when we get to the discussion period to try to draw some links from what I'm going to say to you and the connection, if there is one, between the rule of law and democracy. Just to say a little bit about that, one of the things that struck me immediately after Trump was elected president of the United States of America is that in the two comments made immediately after his election by Hillary Clinton and Barack Obama, where they tried to put a kind of optimistic gloss on things, they both said that their major concern was for the rule of law, what Trump would do to the rule of law. And I think it's because they saw quite clearly, and this has come to pass, that the subversion of democracy often starts with subversion of the rule of law. I'm going to start by giving you a bit of background to the paper and then just mention the main themes of the paper. As Sofie kindly mentioned my book, which appeared earlier this year, The Long Arc of Legality, Hobbes, Kelsen, Hart. And just to say a little bit about that book, the claim of the book, maybe the conceit of the book, is that philosophy of law has been at a kind of impasse for many years. Why? Because philosophy of law has set itself, following Kelsen, but also Hart, with solving what I call the puzzle of legal authority. That is how law can be both a matter of right and might, a matter of both authority and coercion. And legal positivists have had a lot of trouble solving this puzzle because as positivists, they want to avoid any thought that there's a moral basis for the authority of law. And on the other side of the ledger, natural lawyers have a lot of trouble explaining the authority of law, usually because they want to assert too strong a substantive moral basis for the authority of law. And then one can just make the observation that looking across the world today, or looking back in history, there have been many legal orders that haven't instantiated whatever the particular natural lawyer's moral philosophy happens to be. And the way I try to get over that impasse is by going back to Hobbes. As Rainer pointed out, he's sitting just over my shoulder behind me. rather indistinctly. And going back to Hobbes's theory of the modern legal state, which I regard as much more sophisticated than orthodox interpretations of Hobbes usually have it. And according to Hobbes, the state is always legitimate, legal order is always legitimate, which of course raises the specter of authoritarianism, which travels with Hobbes. But what I try to argue in the book is that we have to understand that in Hobbes, there are two kinds of social contracts. So this isn't mentioned in my paper, but I thought it might be helpful to mention it at the beginning of this talk. It's been pointed out by historians of thought that if we look back at early modern thought on the social contract, many thinkers operated with two ideas of the social contract. On the one hand, there was the Gesellschaftsvertrag, which was the contract of all in the society to put in place a sovereign. And on the other hand, there was the Herrschaftsvertrag, which was the governmental contract made between the sovereign and the subjects. And of course, it's the case that Hobbes denies that there's anything like a Herrschaftsvertrag, that is a contract between sovereign and subject. But he does put in place something rather like a Herrschaftsvertrag in his account of law. And that's the account of law that I rely on in the book. I'll say a little bit more about that in a moment. But just another preliminary point. My current project is working on a topic that's explored in chapter 5 of the book, and that chapter is called The Politics of Legal Space. And in this chapter, I attempt to explore the modern legal state by situating different ideal types of state on what I call the Continuum of Legality, which is the continuum where states sit if they operate through law, operate in accordance with the rule of law. And the claim is, and this is the claim I want to investigate more over the next few years, is that different configurations of legal space make different kinds of human rights lawyering possible. And the thesis there, and it's the same as the thesis as the book, is that where there is legal order, human rights lawyering will be possible. And that tells us something about the legitimacy of legal order and the contribution that the rule of law makes to democracy. Now, the inspiration for this project, the project on the politics of legal space, does in a way start in Frankfurt, as it is Ernst Frankel's classic treatment of the Nazi state in his book, The Dual State. And Frankel, as many of you might know, got his legal education in Frankfurt, where the major influence on him was Hugo Sinsheimer, the father of German labor law, and also someone who was responsible for inculcating a sense of the importance of social justice and the connection between social justice and the rule of law in a whole generation of lawyers, including the lawyers of the Frankfurt School, and including the person who's even more indistinct behind me, that's Hermann Heller, sitting next to Thomas Hobbes on my wall. So, more immediately, this is the first draft of a paper for a conference later this year in Australia with the title Responding to Injustice. And the themes of this conference are deeply informed by the work of Judith Sklar, and in particular her book, The Faces of Injustice. And the major theme of the conference is Sklar's criticism of what she calls the normal model of justice, which views injustice, as she puts it, as a prelude to or a rejection and breakdown of justice, as if injustice were a surprising abnormality. And she says that the real realm of injustice does not stand outside of the gates of even the best of known states. Most injustices occur continuously within the framework of an established polity with an operative system of law in normal times. I've been reading Sklar's work on and off for years, as I'm sure many people in this group have. But this is the first time I've tried to read her in a sustained way. And I actually find it fascinating to try to put together various bits of Sklar's work. I'm not sure that she herself thought of having just herself as having just one project, but I'm treating her as if she just had one project. And I'm trying to make sense of that project in a way that I think can be illuminated by my idea of the politics of legal space. And I think her work in turn can illuminate my idea. So that's what the paper is about. And what I focus on in the paper is, first of all, an argument that Sklar is wrong in one respect in regard to her main insight, and that is there is a certain way in which a breakdown in justice is a prelude to injustice, and that is a breakdown in what I call legal justice. That is the kind of justice that's specific to legal order, the kind of justice that one will find in any legal order, however much it might differ from others. And I dwell also in the paper on a second insight in Sklar's work, which again I'll read to you. And this insight I call the Hobbesian Insight for obvious reasons. And the Hobbesian Insight, according to Sklar, is that without juridical institutions and the beliefs that support them, there can be no decent, just, or stable social relations, but only anxiety, mutual mistrust, and insecurity. And I suggest in the paper that if we take Hobbes's own understanding of this insight, we can actually see why maybe Sklar goes wrong in respect of the first insight, which when she says that this normal model of justice, which she attributes to most political philosophers and philosophers of law, has a trouble dealing with the fact that injustice occurs even within normal societies, within operative systems of law. And what I suggest in the paper quite early on is that we should take quite seriously a metaphor that Hobbes uses to understand law. In chapter 21 of Leviathan, Hobbes calls the civil law of the sovereign artificial chains that his subjects have, and this is a quotation, fastened at one end to the lips of the man or assembly to whom they have given the sovereign power, and at the other end to their own ears. So there's this very evocative image of subjects are enchained, but they themselves fasten the chains to the lips of the sovereign, and then the law as this artificial chain stretches to the ears of the subjects. And Hobbes adds that these chains are in their own nature weak, but may be made to hold by the danger and not by the difficulty of breaking them. And I set out in the paper briefly the way that this chain metaphor seems to occur and reoccur within political and legal philosophy, including in the work of Lon L. Fuller, the American philosopher of law, who talked about a bond of reciprocity between ruler and subject that he thought was forged by what he called the inner morality of law, that is the principles of legality to which he thought every legal order must aspire if it is going to be a legal order at all. Now this idea of a bond of reciprocity, a reciprocal relationship between ruler and subject that somehow respects something called the inner morality of law, might seem a far cry from Hobbes with the image of the sword that maintains the legal order. But actually, as Hobbes tells us right at the end of Leviathan, the whole point of the book is to set before men's eyes what he calls the mutual relationship between protection and obedience. So he does claim a reciprocal relationship of the sort that Fuller was centuries later to claim. And this claim might seem to be an attempt to make palatable the truth in the chain metaphor that the threat of the sword of the sovereign, the danger of punishment by overwhelming force, is what sustains law. But I think that there's more to Hobbes's understanding of what sustains legal order and political society than the sword of the sovereign. And that more is something quite similar to Fuller's principles of legality. And these can be found in Hobbes in the chapters where he deals at length with what he calls the laws of nature. And the claim in the paper is that if we look at what I call the legal experience of injustice, the title of my paper, we can see that there is something important to Hobbes and Fuller's claim about law forming this relation, this bond, this artificial chain of reciprocity between ruler and subject. At least I think this is the way one has to understand law. As soon as one embarks on the project of understanding law as a matter of authority, as well as force or coercion. And many of you might be familiar with Hart's, H.L.A. Hart's claim in his 1958 essay in the Harvard Law Review, when he's seeking to move legal positivism away from the command theory of law set out in the 19th century by John Austin. And he says, law is surely more than the gunman's situation writ large. There's a kind of choice there that I focus on in my work, to understand law as a matter of authority. And I want to argue in this project on the politics of legal space and in the paper that the choice that the legal theorist makes to understand law in the register of authority is linked to other choices, linked to the choice to be a lawyer in a legal order, linked to the choice to be a particular kind of lawyer, that is a human rights lawyer, linked to the choice that academics make to teach law, and also linked to the choice that litigants make when they seek to be represented in court by lawyers, even in situations of extreme oppression. So the kind of journey of the paper is to the claim that even in situations of extreme oppression, when legal subjects do choose to be represented in court by lawyers, by human rights lawyers, they are in some way fastening the chains of the law from to the lips of the sovereign to their ears. They're participating in legal order in a way that constitutes the authority of legal order and constitutes it in a way that makes legal order, at least to some extent, legitimate. Sklar's target to support her first claim that political and legal philosophers go wrong in supposing that when one has a more or less decent society and a normal and an operative system of law, there won't be injustice. Her main target is Lon Fuller and the claim that I mentioned earlier, that there's something like an inner morality of law that one will find in any legal order. And Fuller set out in his book, The Morality of Law, 8 principles of legality, which he thought will be instantiated in any legal order. And actually, if one looks at work on this topic, even when philosophers of law divide on many things, they'll usually agree that something like Fuller's principles of legality have to be in place before a legal order can be anything like what Sklar calls operative. But Sklar thought, and here she actually joined Hart and Dworkin, that the rule of law or compliance with these principles of legality is compatible with grave injustice. And in her essay on the rule of law, she has this to say about the compatibility of the rule of law with injustice. She says that and she regards this as a refutation of Fuller. She says that the Nazi case shows that, quoting, the legal castes were perfectly ready to ignore the activities of the new court, police, and extermination system, so long as the inner morality of their law could remain unaffected. And she cites in her support of her claim Frankel's book, The Dual State, which she says is one of the few older studies of the Third Reich that remains valid. And she then goes on immediately to observe that the paradox of slavery that made the slave both a human person and the property of another created a dual state in pre-Civil War America as well. And it was just as rational. No one can be 3/5 of a human being, she says, and 2/5 of a thing, as the federal ratio had it in the original Constitution. Nor is a prohibition against murdering slaves since they were people compatible with their non-person status before the rest of the legal system, not to mention the exclusion from the guiding principles of the political order as a whole. But still, this irrationality, she claimed, may be a model of inner morality and may well serve to render irrationality more efficient and more attractive to those who benefit from it. The dual state, she concluded, remains a constant possibility in our own century. And I think looking around, this is an essay written some 40 years ago, I think, and looking around our world today, I think that this is a rather prescient remark that the dual state remains a constant possibility, not only in the 20th century when Sward wrote these words, but certainly in our century. I think Sward's claim that Frankel's work, The Dual State, supports her refutation of Fuller is flat out wrong. If one reads Frankel's book, The Dual State, which he wrote first in German in 1938 and then translated himself a few years later when he got to the United States, one finds there a book which is really based on his experience as a lawyer in Berlin between 1933 and 1938, which is an unusual experience in itself, but perhaps made all the more unusual by the fact that Frankel was both Jewish and a committed socialist, but he got an exemption to continue practicing law because he had served in the First World War. In The Dual State, as many of you may know, Frankel argues that if one wants to understand the Nazi state, one has to understand it as two states side by side. On the one side, there's the normative state, which is really what's left over from the Weimar period. But on the other side, there's the prerogative state. And in the prerogative state, Nazi officials may do as they will. Any matter that they think should be decided in the interests of the Nazi party, they can decide by fiat. And what's more, they can take any matter out of the normative state and decide it as they want it decided within the space of the prerogative state. And from this, Frankel concluded that there was no rule of law in Nazi Germany. There wasn't, according to Frankel, what Sward describes as an operative system of law. There was something else. There was some kind of legal order, but what happened in legal order was subject continually to the whims of Nazi officials. Frankel, in one of the introductions to an edition of his book, The Dual State, describes his work as follows. He said he often said to his friends that he regarded his work as a lawyer in the 1930s as that of a switchman, by which he meant the person who switches trains from one track to another. He says, that is, I regarded it as an essential part of my efforts to ensure that a given case was dealt with under the auspices of the normative state and not end up in the prerogative state. Colleagues with whom I was on friendly terms confirmed that they too had repeatedly worked towards making sure that their clients were punished in a court of law. But of course, the ability to switch the case onto the legal track depended entirely on whether a Nazi official wanted it decided on that track. And in the end, Frankel concluded around 1938 that there was no point to being a lawyer in Nazi Germany anymore. And if one accepts something like Ronald Dworkin's distinction between legal rights, which are the rights one can have on demand from any adjudicative institution, and legislative rights, which are the rights that we wish our legislature would put into law for us, I think it is arguable that at a certain point in the 1930s, there were no legal rights in Germany, that there was no operative system of law. So I think that what Frankel's classic study, as Sward refers to it, tells us is that under certain conditions, the rule of law will break down. And in a way, as I conclude at the end of the paper, the very possibility of justice breaks down just because one has done away with a operative system of law. What of the other example that Sward offers us? And that is the example of slavery in the pre-Civil War, the United States. I think there she's right that there was a tension in legal order, but she doesn't actually explore the implications of the tension in legal order that made enslaved persons in some parts a human being and in other parts a thing. This tension, and I'll go into some detail about this in the paper, is exemplified in the problem of fugitive slaves. So if we simplify matters in pre-Civil War America and think of there being just one big northern state in which slavery has been abolished and one big southern state in which slavery thrives, built into the Constitution was the possibility for the federal government to enact a fugitive slave law, which it did. There was various iterations of these fugitive slave laws, which required that slaves who escaped from, enslaved persons who escaped from the condition of slavery to freedom in the northern state could be rendered back to the South. And when these people litigated, well, they had lawyers litigating for them in northern courts, the question arose, were they litigating as free human beings, or was the person who was being represented a piece of property which should be rendered back to the rightful owner in the South? That created huge tensions within the legal order. And these tensions were responsible in a considerable degree for precipitating the Civil War. So the tensions that were internal to the legal order in treating a class of persons as in part a person, in part a thing, actually led to the Civil War. Those tensions could only be resolved to the extent that they have been resolved by a war. And it occurred to me as I was looking over the paper this morning, and I'm not the only person that this thought has occurred to, that if we look at current developments in the United States of America, where it seems quite likely the case that once again one will be able to divide the United States of America up into two blocks, states where abortion is permitted, states where abortion is outlawed, that one will get a situation much like the situation of the fugitive slaves, which states will try to control in various ways, for example, by trying to make it illegal for a woman to cross a state line in order to procure an abortion in a state that still permits abortion. So I think that the problems of that attended slavery in the pre-Civil War United States of America are about to recur as things become more fractured in the United States of America. But there is, I think, a difference between the situation of an enslaved person and the situation that existed in the Nazi dual state. Recall that for Frankl, the way to understand the situation in Nazi Germany was that there were two spaces side by side, a space of no law and a space of law, and the space of law was subject to decisions in the space of no law in the prerogative state. That's not the case with slavery. Slavery is a legal institution, and so it's subject to regulation by law. And that creates a tension, I think, internal to every legal order that institutionalizes slavery. One can see it in Roman law. It's very difficult to relentlessly consign by law people to the status of slavery. And that I think is in itself interesting and tells one something about legal order. So I've talked now about one kind of ideal, far from ideal type of state, that's the dual state. And the contrast there is with a rule of law state, where a rule of law state is a state in which politics is subject to law, in that for officials to act, it must be the case that they have a warrant in law for so acting, and one is able, as someone who's subject to their decisions, to go to another official, like a judge, and ask whether the official, in fact, acted within the limits of their authority. The other two kinds of state I want to set out for you, are the two ideal types of state, are what I call the apartheid state and the parallel state. And the apartheid state is, of course, exemplified in the state which I grew up in, that is the South African state. I think many of you will have detected that I don't have a standard Canadian accent. I still hang on to my South African roots. And the apartheid state, on my understanding, is a perverse variant of a rule of law state. Why is it perverse? It was the case throughout the apartheid period that all South Africans, including the black majority, were subject to the same general constitutional norms. What the apartheid state did was it carved out vast exceptions to these norms, which created spaces in which the black majority and also other racial groups were discriminated against. But still, they remained in principle subject to the same constitutional norms as the white minority. That made them into what I call second-class citizens. What are second-class citizens? Second-class citizens are legal subjects who have one foot in the space of first-class citizenship and another in the space of second-class citizenship. I suggested a while back that lawyering, in a way, was impossible at a certain point in the 1930s in Nazi Germany. Certainly, human rights lawyering was impossible, but it was throughout. It was always the case throughout the period of apartheid, even at the worst times, that human rights lawyering was possible. Why was it possible? It's because the black majority were in this status of second-class citizenship, which meant that human rights lawyers could work with the tension embedded in legal order by the fact that the black majority had one foot in the first-class space, as well as a foot in the second-class space. There were only two ways that the apartheid government could have avoided this tension. The one way would have been to create a prerogative state. And at times, the apartheid government did carve out spaces within the legal order that looked pretty much like the space of prerogative that Frankel describes. For example, in security legislation, people were subject to detention more or less on the whim of a police officer. That detention could be indefinite. They were deprived of the right to see a lawyer, and judges were precluded by explicit provisions in statutes from reviewing official decisions to detain people. But still, there was some legal regulation, even though at times was a very thin veneer of legal regulation. There was another tactic that the apartheid state used to try to avoid the tension that's created by having a large group of the population in the status of second-class citizens. And that was to get closer to creating what I call a parallel state. But what is a parallel state? Well, the apartheid dream, or really nightmare, was to set up a system of independent states within South Africa, first called Bantustans, later more euphemistically homelands. But the apartheid government never succeeded in setting up such independent states. So it didn't manage to change into a set of parallel states. And the parallel state that I explore in my paper, the example that I rely on, is the example of Israel and the occupied territories. So what we have in Israel and the occupied territories is supposedly two independent legal orders, with the Israeli state as occupying the Palestinian space. But the claim is that this is done under the terms of belligerent occupation governed by international law, and this is an independent legal order. Well, things haven't worked quite like that over the long period of occupation. At a certain point, as you may know, the Israeli Supreme Court starts taking petitions from the occupied territories, that is, petitions from Palestinians who are contesting what's being done to maintain the occupation. The Israeli Supreme Court never claims that it has jurisdiction. Rather, it takes cases where neither the Israeli state nor the lawyers contest jurisdiction. If it took jurisdiction, it would unify the two legal orders in a problematic way for the claim that one day there will be a two-state solution and it's just a temporary state of affairs, but does take jurisdiction without assuming that it has it, and in this way does unify the two legal orders. But it tries to maintain the seal between these two legal orders through not permitting the constitutional norms of the Israeli state to seep into the space of the occupied territories. Now, in my paper, I set out just why this experiment is not very successful. The norms do seep in both directions, both from the space of the Israeli legal order into the occupied territory space and vice versa. But what interests me most about this parallel legal order is that even though the Palestinians who are in the occupied territories are subject to a very oppressive system, still human rights lawyering is possible. Why? Because of the tensions that ensue in trying to manage this very complex political situation legally. And here I rely on a book which I think is really quite wonderful by an Israeli human rights lawyer called Michael Sward, whose practice is in the occupied territories. And Sward, in his book, The Wall and the Gate, tells us that the situation of a human rights lawyer in the occupied territories is morally very complex, even fraught, so fraught that he sometimes thought, as have other lawyers, of giving up their practice. What makes it so complex, he says, is that the human rights lawyers operating in the space know that they can never change through their practice the regime which they regard as unjust. And what's more, their victories in court, as well as their losses, help to shore up the legitimacy of the regime. Nevertheless, he continues in his practice because I think most of all, it's the case that there are people who are crying out for the kind of assistance that he and other human rights lawyers can give. But he also has a sense that continuing in his practice is important for instilling what he calls a culture of good government, which he hopes will prevail in a better future for all in this place, Israel and the occupied territories. And in making this claim about a culture of good government, he relies on a debate which took place in South Africa in the early 1980s, which I spent some time on in the paper. So this, by the way, was at the time when I just started teaching at my university's Faculty of Law, and I took part in this debate, and I've always found it fascinating. But the debate was mainly between two figures. One, a man called Raymond Wax, who had just been made a professor of law at a university in South Africa, and he called on judges in South Africa, the liberal judges, the few liberal judges on the South African bench, to resign. Why? Because he thought that they were participating in shoring up the legitimacy of an unjust regime and were doing more harm than they could do good, given that the space for human rights lawyering had shrunk to a huge extent. And he was opposed in this debate by someone who was my main mentor as a student, international lawyer called John Dugard. And Dugard argued that the space for human rights lawyering was bigger than Wax suggested, but also that one shouldn't focus so heavily on judges, because all lawyers participate in shoring up the legitimacy of the regime, even the human rights lawyers. So if you wanted a sympathetic judge as a human rights lawyer to hear your case, you shouldn't be arguing that those judges who might be sympathetic should resign from the bench. And Dugard also clearly in this in his response to Wax, had his eye on the future, that it was important to keep alive this idea of a culture of good government. And indeed, that idea of a culture of good government has been tremendously important, as some of you may know, in post-apartheid South Africa. One thing that Sward doesn't touch on in his recounting of this debate is that when Wax made his argument, he made his argument on what he regarded as Dawkinian grounds. That is, he claimed that if one took Dawkins' interpretive theory seriously, it was the case that at the time that he was writing, the best interpretation of apartheid law in any hard case was an interpretation that would be based on the principles of the racist ideology of the government. And I think that the most interesting issue that's raised by the debate between Wax and Dugard is whether the principles of a racist ideology like the ideology of apartheid can be made into the animating principles of a legal order, whether that kind of political ideology can in a way become the perverse principled basis of a legal order. And I want to suggest that actually such an ideology cannot be made into the principled basis of a legal order. And perhaps the apartheid state illustrates this claim. That is, in order to get rid of the possibility of, let's call it genuine human rights lawyering, the apartheid state would have had to change either into a prerogative state or to succeed in setting up a set of parallel states. But to the extent that it remained an operative system of law, or what I would call a rule of law state, it was the case that apartheid ideology could not become the constitutional set of principles of the apartheid legal order. And I think that the parallel state that exists as between Israel and the occupied territories can serve to make the same kind of point. And that is that as long as one has in place an operative legal order, any attempt to put in place an oppressive political ideology will create tensions that make it the case that human rights lawyering can work in that legal order. Now, to the extent that human rights lawyering is possible, one does get a legitimation of the legal order, not only in a sociological sense, but I think in the sense that there is a kind of moral quality to the law that governs people's lives that's imparted through the work of human rights lawyers. And one can, therefore, I think, see why it's the case that human rights lawyers participate in fastening the chains of the law from the mouths of those they represent to, at least from the ears of those they represent, to the mouth of the sovereign authority. But I also want to claim, and I think this is the most controversial claim, that the litigants themselves participate in fastening those chains. That is, that when Palestinians in the occupied territories choose to go to court, they are, in a way, establishing a bond of reciprocity between them and the sovereign that does help to legitimate the legal order, even though it's a legal order which they probably rightly regard as highly oppressive. And that then links, I think, in an interesting way to the choice that legal theorists like Hart make when they try to understand law as a matter of authority as well as coercion. Now, there might be a good reason to take what Hart calls an external point of view on legal order. That is, to forego trying to understand why it is that participants in legal order accept the authority of law and regard law as just a system of coercion designed to instill a habit of obedience, as John Austin called it, in those who are subject to law. But the claim that I make towards the end of the paper is that this habit of obedience is a habit whereby it's the case that legal subjects do participate in the construction, the constitution of legal authority. And that tells us that there is something to the thought that a breakdown in legal injustice is a prelude to a breakdown in legal justice is a prelude to injustice writ large, because that such a breakdown either betokens a change in the nature of the legal order, say from an apartheid state to a parallel state, or to the end of legal order, as happens when one has a prerogative state next to a normative state. And Hobbes, to go back to my main inspiration in all of this, tells us, as we all know, in chapter 13 of Leviathan, that there's no possibility of justice in the state of nature. And similarly, I want to suggest to you that there's no possibility of justice when one has a dual state, and that this does tell one that there is some kind of legitimacy to legal order just through having in place what Clark calls an operative system of law. I think I've probably gone over time, but I've finally got to the end.
Thank you very much for this lecture. We now have the first comments by Chiara Destri, who's a postdoctoral researcher here at Goethe University. Before that, she's been a Marie Curie Fellow at Sciences Po, a postdoctoral fellow at Justitia Amplificata, and a Max Weber Fellow at the European University Institute in Florence. Her work has been published in Critical Review of International Social and Political Philosophy, in Res Publica, and Ethical Theory and Moral Practice. So please go ahead, Chiara.
Thanks a lot, and thank you very much for this rich and thought-provoking piece. I have a few questions that hopefully will help basically spark the discussion. So I will just focus really on asking questions about the paper. Before doing that, just a minor point of style. I think the paper is very rich, but also very dense. So if the aim is to publish it as a paper in its own right, I think the reader might need some help to be guided throughout the argument, because otherwise it gets a bit difficult to follow the line of the argument. It's just a minor comment. But the questions. So I think the main thesis is really interesting. And I have a few questions concerning, first of all, the connection between human rights protection and the legal system, in the sense that it seems that what gives presumption of legitimate authority to the legal order is also the fact that a legal order makes human rights lawyering possible, meaning that it allows for the protection of human rights. And so if that's correct, if this rendering of the argument is correct, I was wondering, first of all, if it is really the case that that legal order always protects human rights. And what I'm thinking is that if we think we have a human right, to democracy, rule of law system is compatible with the absence of democracy, right? And so in that respect, it doesn't seem that it would protect all human rights. So I was wondering if that's possible. And secondly, I was wondering if the contribution that the rule of law provides for democracy is a contribution that in a way goes through human rights protection, or is there any other form of direct contribution that the rule of law can offer for a democratic system? And then I had a question about the continuum of legality of the different systems. And if I understand the paper correctly, in a way, we can start with the dual state, and then we have slavery, and then apartheid and Israel as different forms of parallel state. The apartheid is not a perfect parallel state, whereas Israel is more similar to the ideal type of a parallel state. And this is a perverse version of the rule of law, of a rule of law state, that is the morally decent at the end of the spectrum, let's say, of this continuum of legality. And I was wondering, is the distinction between these different points in the continuum?
Chiara, we lost your audio.
Can you hear me now?
Yes.
Okay, great. Sorry. So I was wondering, is the passage from one point to the other in this continuum a matter of the level of inclusion of human beings as dual subjects? Is it also a matter of the strength of the protection of human rights? Is it also a matter of the amount of human rights, that amount of rights that count as basic human rights that the law protects? So I was wondering that the passage from one step to the other, is it just a matter of inclusion? Because it seems partly that at least the passage from slavery to the parallel state is about inclusion, but the passage from the dual state to slavery, it's not only that, or I mean, it's partly that, but not only. And then my last point, I had a very basic question that is mostly, I would say, a clarificatory question, because it seems to me that a strong point of the argument is that the fact that the legal order is necessary for justice means that to a certain extent you cannot have grave injustice within a given legal order. And that's where Schlar is partly wrong, if I understood you correctly. But it seems to me that the fact that the legal order is necessary doesn't mean that it cannot coexist, right? And in particular, the fact that it's necessary for legitimate authority doesn't mean that it is sufficient. And so I was wondering what's the point there? And also connected to this and connected to the last part of the paper, I was thinking, is the protection of human rights a necessary element together with the sociological fact of obedience? Or could you have obedience without protection of human rights? Because if that happens, if you can have
we lost you again.
I'm so sorry. I don't know why that happens. Can you hear me now?
Yes.
Okay. So I was thinking, if the obedience is enough, so in a way, one can think that obedience is not enough to ensure the acceptance of the legal order, and the acceptance is not enough to ensure the protection of human rights. And so I was wondering to what extent obedience works only if it's coupled with the principles of legality, Fuller's principles of legality, and a certain amount of protection of human rights in your view. So I think that's it. Thank you very much, and I look forward to the rest of the discussion and your answer. Thanks.
Right. Before giving Professor Dyzenhaus a chance to reply, we will have a second comment by Professor Uwe Volkmann, who's now joining us. Professor Volkmann is a professor of public law and legal philosophy at the Goethe University Frankfurt, and he's a member of the Research Cooperation Initiative on Social Cohesion. He studied law in Marburg, and before coming to Frankfurt, he was a professor of public law and legal philosophy at the University of Mainz. He's published 8 books in German, including works on solidarity, programming principle in the Constitution, and a handbook on legal philosophy. So please go ahead with your comment.
Yeah, thank you very much. And once again, excuse me, I have to apologize for having left you for some time, but I hope I did get everything right. First, I have to start with 2 confessions. The first, it was an insightful and indeed, as Chiara already said, very dense paper. It was, I must admit, quite hard for me to read. And I was really grappling with what to say or better to add to it. As far as I understand you, David, you are trying to combine the positions of 4 entirely different thinkers, Sklar, Dworkin, Hart, and Fuller, and maybe Hobbes and some others too, and to squeeze them together in some kind of synthesis. The main idea is, or seems to me, that among them the crown witness, maybe a bit hidden, but still the crown witness is Lon R. Fuller with his discovery of the inner morality of the law. And the main idea seems to me to stretch this inner morality a bit further into the direction of Dworkin and up to a point where even Hart or Sklar would not dare to disagree. So that was my impression. Second confession, starting to read the text, I had really mixed feelings, to say the least. It started with a reflection of Sklar's Phases of Injustice, which in all its vagueness is some kind of hidden treasure, I think, in legal philosophy, still waiting to be explored more thoroughly. And I thought, oh, this might be interesting. But then on page 2, H.L.A. Hart appeared, and I just waited for Dworkin to enter the scene, which he admittedly a bit late did on page 6. And I thought, oh, this is just the next contribution to the endless Hart-Dworkin debate, which particularly Anglo-American legal theory is, in my opinion, kind of obsessed with. And I, as a German reader, find this debate somehow tiresome in the meantime. And normally, once I see that this is just another contribution to that debate, I close the book and move on to something else. But this I found interesting. And it is interesting because it offers a new and fresh view on the problem as such. And it does so because it brings into new, at least new to me, 2 new perspectives. First, it looks at the debate not from the angle of justice, but informed by Sklar from the angle of injustice, by asking to what degree injustices may occur within a given legal system before it ceases to be what we can legitimately call a legal system. And second, it illustrates the border between these two with the example of human rights lawyering in, at least to some degree, unjust regimes. And this is really a striking case where I think where it really comes to the clash. And putting together these concrete examples with the general problem, I found highly insightful and fruitful. But as I agree largely with the result and the depiction as well, I of course asked myself what I could usefully contribute to it. And the only thing that came to my mind was to dwell a bit on the very nature of the content of justice. That is, to ask, what do we really mean when we speak of justice or injustice in these cases? And with regard to that respective content, what is the specific relation to the law? And is there a specific relation at all? So that we can speak of legal justice or legal injustice in the way you, David, have used the term. Because in the text, there's a lot of talk about justice and injustice, but it took me some effort to grasp the specific features of it, or faces, as Judith Clark said, in the sense of a clear definition of justice or injustice, because in most cases, it simply seems evident why something is unjust, so there's no need to explain. And this applies even more to Sklar's book itself, which gives various telling examples of injustice, but fails to systematize, let alone to name them. And this is the point I want to dwell upon a bit by asking, what is the substance? What can be the content of justice justice. What is it that we call just or unjust in the application of the law? And I take up your distinction, the distinction with which you started, the distinction between legal justice and external justice, or as Hart called it, justice in the administration of the law and justice of the law. And my question now is, what does legal injustice mean, and what kind of injustice is there or may there be in the law? And I have a small presentation, and I would like to share my screen so that you need not look on my bearded face all the time. And I just start here in presenting it. Here you see the headline, what can legal injustice mean, and in which forms can it occur? And I think it can occur in 3 forms. And the first has to do with the general nature of the law as a general and abstract norm, and refers to what Aristotle called the problem of equity, epieikeia in Greece. And we have a famous example from German history there. In 1922, someone entered into a contract with someone else for the purchase of a piece of land. And they agreed on a price of 10,000 Reichsmark. But the maturity was postponed for 1 year. And then the inflation came in between, and 10,000 Reichsmark, for 10,000 Reichsmark, you couldn't even get a slice of bread. And the question now was, how much do you have to pay now in 1923? And normally in every legal order, we have a norm that says you have to pay the price that has been stipulated. But of course, this doesn't fit to the individual case. And there is some kind of legal injustice coming from the general character of the law. And is that what Aristotle called the problem of equity. The law is not wrong, he said. There's no flaw in the law, but as an abstract and general norm, it simply cannot do justice to every single case. And this kind of legal injustice is characterized by 2 specific qualities. First, it is inherent to the law, and thus cannot be avoided entirely. We can try to minimize it by opening up the law to the peculiarities of the individual case by some equity clauses, or we can keep the wording of the law, that is a certain legal norm, very vague, give it a very broad and open texture, thereby leaving room for interpretation. But I'm not sure whether this really is a solution within the law, or whether it is in some way or the other alien to the law by offering a way to go beyond the law. So, and the second feature, there's no real counter term on the side of justice, because what can legal justice mean in that case? We can, of course, call it individual justice or justice in the individual case, but as such, there will always be some cases where the law as a general norm fails to achieve it. So the law can strive to achieve it, but it is doomed to always lag behind. The second kind of legal injustice we might all agree upon is inequality in the application of the law, as a violation of a general idea of justice, that equal cases should be treated equally. The features of this kind of injustice are just inverse to those of our first type. First, it is more or less alien to the general nature of the law, to the very nature of the law. And on the other hand, we can clearly say what injustice in this case, or what justice in these cases really means. And then we have a third kind. So the problem is the problem of arbitrariness we are facing here. And from there we go on to a third kind of injustice that is not related to law as an abstract rule, but to the process of its realization, to the process of its becoming practical. It's the difference between having a right and try to get it in legal proceedings. And this has to do with the inherent limits and deficiencies of legal proceedings. It is this example what we might call, according to Sklar, the Pickwick problem, because she presents it as a story from the famous Pickwick Papers by Charles Dickens. At the beginning, we have an apparently easy and clear case which is presented to us, but as this case is brought before the court, the clearness and easiness somehow fade away. Witnesses give false testimony or do not remember what has happened. The case gets into the hands of pettifogging lawyers, and at the end it all gets worse. So these are kinds of injustice or types of injustice which in some way or the other are inherent in the law. And the question is, from this side, do they affect the general intuition that law is in some way or the other necessarily linked to some idea, some basic idea of justice? Now, a comprehensive answer would take me much longer than the few minutes left here, but on the whole, I do not think so, because any legal order is in itself constantly aware of these problems. They are constantly addressed and reflected in the application of the law itself, and any legal order does as much as it can do to avoid, or at least, which may be the same, to conceal them. So now let us come to the other side. What can legal justice mean, and in which respect can we speak of specific legal justice? Well, and I think there we also can distinguish three phases or three forms of legal justice. And the first comes from the character of the law as an order of more or less peaceful coexistence. This is responding to the Hobbesian problem, or to Hobbes' problem, and this is to his insight that a legal order, whatever its content, is at least to some degree preferable to a state of complete lawlessness. And it is this was what Radbruch in his famous essay on statutory lawlessness, which is quoted in David's text, called legal certainty as a value of every legal order. To quote it, he said, "To be sure, one value comes with every positive law statute without reference to its content. Any statute is always better than no statute at all, since it at least creates legal certainty." And I think this is related to justice, as it replaces the civil war by some kind of peaceful coexistence, brute force, and the right of the strongest by rules of mutual constraint. Radbruch, however, pushes the concept of legal certainty also in another direction. And he said legal certainty is required not only for the public benefit, but also for justice. That the law be certain and sure, that it not be interpreted and applied one way here and now, another way elsewhere and tomorrow, is also, he said, a requirement of justice. And this is what we call just equal treatment of equal cases. And I think we can understand this too, like Radbruch, as a commandment of the law itself, and on the other hand, as a commandment of justice. Now, some people like Kelsen say we are mistaken if we consider this as a specific claim of justice. It is, they say, simply the nature of a legal norm that it is only applicable to those cases which can be subsumed under it and not to others. But I think Kelsen underestimates the driving force of this idea. First, the idea can be violated, like in autocratic regimes where, for example, members of the ruling family are tacitly exempted from the validity of legal legal norms. And second, we need the idea as an idea of justice in the open texture of norms. That is where the law leaves room for different interpretations or for discretion. Here it is not the law that is a special legal norm that tells us that equal cases should be treated equally, that they should be the same way that they have been treated before, but a general idea of justice. So I subsume this under Radbruch's concept of legal certainty. And then the crucial question is, and I think here it becomes a bit tricky, if we can go some steps beyond this point without losing heart and others on our way. And I think we can do so because of the specific way how the law addresses and treats its subjects. It does not address them as the concrete human being they really are, as David Dyzenhaus, Chiara, Destri, or Uwe Volkmann, in their flesh with all their abilities, their characteristics or emotions, as a man or a woman that can hate or love. Instead, it regards and addresses them in a very general and abstract way, that is, as a legal person. And as a legal person, if they are treated as a legal persons, they are given something which we call legal capacity. And that is a concept every legal order has to work with. Otherwise, it is not a wicked or unjust legal order, but no legal order at all. And rooted in this basic capacity, being a legal person, being a person at all, is a basic element of equality, which also commands the relations between each other, which tells us something about people are seen by the law and how they are supposed to see each other. This is famously expressed or addressed by Georg Wilhelm Friedrich Hegel in the famous paragraph 36 of his Legal Philosophy, when he said, oh no, it's not here, I just have to go back, just one moment. When he said, the command of the law, therefore, is be a person and recognize the others as such. And if we have reached this point, we come to our final question. And I think this is the question David tries to address. Is there a direct link from here, being a legal person, being addressed as a legal person, to something that I would like to call a human rights conception of justice? Is this necessarily pointing towards something like human dignity or like Dworkin's right of equal respect and concern, which he considered as the basis of any political morality? For if it is this can be taken as a bridge to a broader, more substantive concept of legal justice, which is indeed inherent in a legal order. And once again, we may find such a bridge where we do not assume it in Hegel's Legal Philosophy. And here in a longer footnote to paragraph 270, where Hegel expressly advocated the emancipation of the Jews in the beginning 19th century. And we have here Hegel speaking from his grave on his cemetery in Berlin to us. And this is what Hegel here says. So two states, he said, have had a formal right against the Jews in regard to the concession to them of civil rights, because they are not merely a religious body, but claim to look upon themselves as a foreign nation. So this is maybe discriminating, this is old-fashioned. Do not have to look at this, but important is what follows. But the outcry, Hegel says, but the outcry raised against them on this and other grounds has overlooked the fact that they are first of all men, and that to be a man is more than a flat and abstract quality. The civil rights implied in it give rise to a feeling of self-respect, Selbstgefühl in German, the sense of counting as lawful a person, as a legal person, we might say, rechtliche Person, in the civic community. And in my opinion, this idea, counting as a legal person or as a lawful person, as it has been translated here, may give us the link we are looking for. Because in this claim, there is something looming which demands to be fully developed, which gives us a tool to question any fundamental distinction of value between human beings. Okay. Maybe a bit too long. Thanks. I apologize for this again, but well, that was my contribution.
Thank you very much for this. And Professor Dyzenhaus, you now have around 10 minutes to respond to these comments.
Okay, 10 minutes, there's a lot there. So let me start off by, first of all, thanking you for your comments and expressing complete agreement with the comment that's common to both of you, that this is a very dense paper. It's the first draft of a paper, and I confess that I'm using this audience, and particularly my two generous commentators, as kind of guinea pigs to try to make the paper easier to grasp for the reader. So you're in the unfortunate position of having the first draft inflicted on you. Do I think I'll start with Chiara? What is the connection between human rights and legal order, given, as you put it, that raises the question, if we suppose that there's a human right to democracy, is there a connection between legal order and that human right? So that raises the the question starkly, but I think one could choose a bunch of different human rights and ask this question. And why is it such a pressing question? Because we know that there are many undemocratic legal orders situated in undemocratic states. And so how can one make this claim? Part of what I want to argue in this paper, but also in other work, is that there's a certain virtue to looking at the rule of law and asking what it can deliver for those who are subject to law, quite apart from whether the issue of whether or not it's nested, the legal order in a democracy. So does the rule of law give us something, even if it's the rule of law in an undemocratic state? And I think it does. But I do think that there's a tension between trying to rule through the rule of law and at the same time maintaining an undemocratic political form of government. And that tension comes about because of the thought which I try to support in the paper, that as soon as one has in place a rule of law state, there is forged this bond of reciprocity between sovereign and subject, in which the subjects participate in constituting the authority of law. And if one situates a legal order within an undemocratic state, that I think does raise the question for the political order. Why is it the case that that bond of reciprocity does not exist within the political institutions? And here, and maybe from time to time, I'll refer to both sets of comments. Just to say something about Uwe's suggestion that this hot walking debate is tired, turns people off. Unfortunately for me, perhaps this debate I've been concerned with during my whole career. But it is because I thought that the stakes in this debate were bigger than either Hart or Dworkin perceived. And this is the reason why in this book, which I hope has by now landed in your office, The Long Arc of Legality, Kelsen figures so prominently in my argument. So remember, the subtitle of the book is Hobbes, Kelsen, Hart. Dworkin, although he's a prominent player in the argument in the book, isn't prominent enough to figure in the title. And the idea is that if we look at Hobbes's legal theory and then try to understand how Kelsen updates Hobbes's theory of the modern legal state for the 20th century, we can actually understand much better what the stakes were and are in the Anglo-American debate as between, say, Hart and Dworkin and Hart and Fuller. And the idea is that we should be able to situate legal theory more within political theory. And I think one can make this connection and in a way perhaps start to answer Chiara's question by looking at Kelsen. You mentioned, Uwe, that you thought that Kelsen's response to the issue of equality, as you raised it, was inadequate. And I think generally Kelsen vastly underestimated the resources of the pure theory of law for addressing political questions. And I think it's very interesting to look at his first work on democracy, which he wrote in the 1920s, The Nature and Value of Democracy, and think of it as a work that actually has exactly the same methodology as he has in his pure theory of law. And one can draw a very tight connection between the workings of legal order as Kelsen understands it and his understanding of the workings of a democratic political order, such that one can see that there is a kind of tension that arises if a state genuinely commits to ruling through law, but wants to remain an undemocratic state. I think the category of the legal subject has some kind of elective affinity, one might say, with the category of the political subject of a democracy. And so the installation of the legal state in Europe over the centuries, in a way, demands the eventual move towards democracy. Now, when it comes to the contribution, to move back to Chiara, of the rule of law to democracy, does it go through human rights or elsewhere? I know this isn't nearly clear enough in the paper, but I'm operating with a fairly minimal conception of human rights in the paper. So maybe not the full panoply of rights that one associates with human rights in our century or in the latter part of the last century. I think where human rights begins is with a certain claim to equality of all legal subjects before the law. And here, actually moving back to Uwe and to your mention of Radbruch, I take a great deal of inspiration from Radbruch, because Radbruch in the passage which is supposed to express the Radbruch formula does say that the true core of justice is equality, and it's when the law betrays its commitment to that kind of equality that it ceases to be law. And the way that I try to combine this vast cast of characters together in this paper, and also in my book, is to suggest that if we look at these ideal types of state, we can see what happens when a legal order starts to betray this core commitment to equality, which is a very formal idea of equality before the law. Either it ceases to be a legal state, which I think you suggested you might be in agreement with, or it changes from one form of legal state into another. But that also has consequences for legal subjects. So that's the light that this idea of ideal types of state is supposed to shed, if it does, on this really deep question about if there is such a thing as legal justice, that is a justice peculiar to law, that one will find in any legal order, no matter how oppressive that legal order is. And if that legal justice has to do with something like the formal equality of all legal subjects before the law, what kind of substance does that commitment to deliver? And it seems to me that when those lawyers we call these days human rights lawyers are doing their work, under often very arduous conditions, they are working at bottom with that commitment to formal equality, which is sometimes, sometimes they get a lot of help from the fact that the legal order has constitutional commitments to various kinds of substantive rights. But as long as there's that formal commitment to equality, I think that human rights lawyering of a sort is possible. So that's really where I would try to cash out more my idea of legal justice. And the thought that I take from Fuller is that if one tampers too much or undermines too much formal equality before the law, that actually does damage to the fabric of legal order. Now, when it comes to the other point, I've now got 8 pages that I scrawled while people were making their comments, and they've got totally jumbled together. When it comes to the point that Chiara made about the continuum of legality and what marks the shifts from one kind of state to another, I think it does have to do with the factor that you mentioned of inclusion. Because legal subjects can be excluded or persons can be excluded altogether from from personhood, and they can be made into slaves, and that creates a different kind of problem from the problem of stripping people of some features of first-class citizenship and turning them into second-class citizens. And where a state is placed on the continuum of legality will depend on exactly what it's doing in regard to inclusion and exclusion, and or how it's managing just partial exclusion. Now, in the book and in the chapter from which this paper is mostly extracted, I identify another kind of state, but I didn't feel that I could burden this already dense paper with this other kind of state. And I argue in the book that if one looks at the pre-Civil War situation in the United States of America, what one sees is actually what I call a hybrid state. And what is a hybrid state? A hybrid state is a state in which there will be spaces of prerogative, there will be spaces of discrimination, which will turn groups of people into second-class citizens. And I suggest that actually all states are, all legal states are hybrid states. And the way in which they construct these different spaces are, will tell one where they should be placed on the continuum of legality. There's actually a very interesting paper, which I don't think I cite in the footnotes in the paper I prepared for this lecture today, which was given at the symposium on justice for hedgehogs that was held at Boston University by Suzanne Sridhar and Candice Delmas, where and it was I'm not sure whether they refer to Sklar, but it's actually in a way a very Sklarian paper. Because I say if one takes Dworkin's idea of dignity as somehow the core legal value seriously, one will see that even the most decent states, or even the best candidates that we've seen so far for decent states, do trample on the dignity of many of the subjects all of the time. And I do think that this is going to be a feature of legal order and political order. One can't get away from it. There is a kind of injustice built into legal order, as I think Uwe mentioned. But that what legal justice can do is to bring the injustices which are going to be perpetrated in the name of the law to the surface, make explicit what the substantive injustices are through breakdowns in legal justice. And that then poses a question, not so much for judges and lawyers, but for the political community as a whole. What are they going to do about these tensions that are being created in their political order through inflicting injustice on people through law? So that's, I think, the main work that human rights lawyers can do. And indeed, if one reads, as I think everyone who's interested in these issues should read, Michael Sward's book on human rights lawyering in the occupied territories, that's in the way the aim of his practice is to make the occupiers face up to what they're doing. That's the most that his work as a human rights lawyer can achieve. He's not going to win, he's not going to be able to overturn the regime against which he struggles in court. So is grave injustice ruled out? I think picking up on comments that both commentators made, yes, I do want to claim that a certain kind of grave injustice is ruled out through having the legal order. That's the injustice that occurs when the law reduces persons to a status that's less than something like abstract personhood. So maybe since I've probably spoken for my 10 minutes or more, I'll just stop there for the moment.
Can I just say something to the hard walking debate? Sofie? Just well, when I referred to the hard walking debate, I said it was a bit tired. It was mainly meant as an encouragement, because your text, in my opinion, is very dense and somehow over complex, because you try to situate your argument somewhere in the hard walking debate by taking up arguments from various sides and dealing with them. And I just wanted to encourage you to rely on your own way of thinking, on your own way of argumentation. And this human rights lawyering case, I think, is highly illustrative. You can really show a lot with this, and it was not more. It was not meant to downplay the significance of the hard walking debate. Yeah, just to make that clear.
Thank you.
Great. Thank you. Orders to give a final remark. So now I'm starting the recording again, and please go ahead, Ryan.
Oh dear, if the recording is on, I get nervous. No, this is just a very brief thank you. Thank you, first of all, of course, to David for this wonderful lecture, and to Uwe and Chiara for the comments. But also, since this was the last talk in that series, it is a big thank you to you, Sofie, and Carlos, for having organized such a brilliant set of lectures, continuing from a year ago, where great people like Christina Lafont, Herlinde Bauer-Studer, and Klaus Günther spoke, and this time having Neil Walker, Shauna Schifrin, and David Dyzenhaus is just a great lineup of wonderful legal theorists, legal philosophers who inspire us a lot. Sometimes people ask, what is normative orders? And so here one could go Wittgensteinian. You know it when you see it, right? It's what we do, and what we do is engage with such great scholars and thinkers, including you too, Sofie, and Carlos. Your own work is also exemplary for the disciplines you work in, law and philosophy. And so this is a great thank you for having established such a great lecture series. And I hope there will be a continuation. Thank you very much.